Well, good morning, or sorry, actually, good afternoon, everyone. My name is Quynh Tran, and I am Head of Regional Policy and Public Affairs at IFRRO. Firstly, my many thanks to IPK for inviting me to join you today. I'm really delighted that I can participate. So just a bit about IFRRO. We are the global umbrella organization for collective management organizations in the text and image sector, which is otherwise known as IFRROs. The IFRRO community is comprised of both publisher and author representatives, and we have over 155 members across 86 countries. And together we represent millions of text and image holders from all over the globe. IFRRO is deeply committed to advocating for creators' rights and also to supporting the good practice and progress for collective management frameworks all around the world. I just wanted to take a moment here to highlight some of IFRRO's activities in this region. So IFRRO's Asia Pacific Committee is comprised of IFRRO members who have interests in the region. And currently there are 17 organizations from 13 different countries. The committee is currently chaired by representatives from Singapore and also Hong Kong. And it plays a really important role as a standing advisory body to the IFRRO board and brings members together to discuss issues of regional significance. IFRRO currently also has 5 active members in the ASEAN region, and over the past 18 months, we've offered a targeted mentorship program for our ASEAN members in order to support the establishment of a viable collective management licensing system in countries including Vietnam, Malaysia, Indonesia, and the Philippines. IFRRO participants meet regularly online and also in person annually to discuss IFRRO best practice and also to progress against discussed tailored business plans. And in addition to these overarching programs, IFRRO also supports members in terms of areas of national interest, and this can include advocacy on legislative issues and also training on best practice. Some of you, I think, in this forum may not be too familiar with collective management and its importance to healthy publishing industries. To give an example that collective management, of the role that collective management can play in fostering really thriving publishing sectors, globally, for instance, IFRRO's members collected over €1 billion last year. In 2023, Copyright Agency, the Australian IFRRO, distributed close to, I think it was 142 million to more than 36,000 rights holders. And to look at an ASEAN example, between 2017 and 2022, the Singaporean IFRRO class distributed over $20 million to rights holders. And this also indirectly benefits many others involved in the creative sector, such as in-house writers and illustrators. On a more individual level, collectively managed rights are a really important revenue stream for authors. A study that was carried out in the UK some time ago found that 25% of authors receive more than 60% of their income from secondary uses. And this study also found that for authors, a 20% reduction in secondary licensing income would result in the equivalent of almost 3,000 fewer works being created annually. So IFRROs exist to offer efficient and comprehensive licensing solutions that facilitate fair and, importantly, remunerated access to quality materials. And from our perspective, this benefits both users and creators alike. So the creative industries, as my colleagues have highlighted before, undoubtedly have some significant social impacts, such as promoting social cohesion, well-being, and also, particularly for the publishing sector, contributing significantly to improved education standards. Beyond these very important social impacts, the economic impacts of healthy creative ecosystems are substantial. As noted in the 2021 report for the OECD Culture Working Group, culture and creative sectors are a significant source of jobs and income and also generate important spillovers to the wider economy. They are a key driver of innovation, a source of creative skills that act as a major magnet to drive growth in other sectors such as tourism and export, and nowhere is that more clear than in South Korea just now. A 2022 UNESCO study showed that the creative industries contribute significantly to national GDP, with the publishing sector actually as the single most important sector in many countries. And the importance of IP protections and robust IP frameworks in fostering innovation and the development of sustainable IP-intensive creative industries must not be understated. Indeed, this was noted by the director of the Hong Kong Intellectual Property Department, Mr. David Wong, when he gave a fantastic keynote speech at IFRRO's Asia Pacific Committee meeting earlier this year. In observing that IP-intensive industries accounts for an extraordinary 32.7% of Hong Kong's GDP and 29.1% of the total employment in Hong Kong, Mr. Wong emphasized the role of robust and agile IP frameworks in balancing the needs of users of IP products, that is consumers, and the rights holders, that is IP owners and investors, in order to foster true innovation. So, here comes AI. Where do we start? I mean, let's firstly start with some truly extraordinary statistics. A recent PwC Global Intelligence report shows that AI could contribute up to $15.7 trillion to the global economy by 2030. And this is more than the current output of China and India combined. Of this, it's projected that $6.6 trillion is likely to come from increased productivity, and $9.1 trillion is likely to come from consumption side effects. Importantly, and very tellingly, I think, the greatest economic gains from AI will be in China with a 26% boost to GDP in 2030, and North America with a 14.5% boost. And this is the equivalent of a total of $10.7 trillion and accounts for almost 70% of the global economic impact. In terms of uptake, according to OpenAI, ChatGPT acquired 1 million users just 5 days after launching at the end of November 2022. By comparison, it took Instagram approximately 2.5 months to reach 1 million downloads. And poor old Netflix had to wait 3.5 years to reach 1 million subscribers. Statistics from the World Intellectual Property Office indicate that while digital technology patent applications have grown across the board 170% faster than average over the past 5 years, AI growth is currently sitting at over 700%. Generative AI now accounts for more than 1/5 of all AI-related patents, and this number is rising very quickly. If you believe the hype, and gosh, there is a lot of it out there, in terms of potential economic growth and consumer uptake, the opportunity is enormous. However, the rapid development of AI technology has created a hugely unpredictable environment for creative industries. On the one hand, of course, and as Abbas highlighted earlier, many in the creative sector are already deploying generative AI as a tool to assist the creative process. Many publishers, for instance, have already embraced AI technology to reduce administrative burden, to address workflow issues, and to enhance efficiencies. And on the other hand, it is also true that many are deeply concerned about the existential threat that generative AI may bring. Earlier this year, IFRRO member DAX, a UK visual art CMO, carried out a substantial survey of UK artists, and this survey revealed 95% of artists feel that they should be asked before their work is used to train AI models. 93% of respondents felt they should be credited when their work is used for AI training. 94% of respondents felt that they should be compensated financially when their works are used for AI training. And critically, most importantly, 96% stated that they had never given permission for AI models to be trained using their work. The concerns of existential threat are not unfounded, and they can be understood from a number of perspectives. Firstly, there is the profound lack of fairness in the training process. Soon after the advent of accessible generative AI tools such as Stable Diffusion and Midjourney, creators were very quick to call out concerns that their works were being used to train AI without their permission and without pay. In exposing the Books3 database in a series of articles for The Atlantic throughout 2023, the journalist Alex Reisner highlighted the rampant and unfettered use of unauthorized copyright materials in training generative AI models. And this was all done without consent, without acknowledgement, and without remuneration to the creators. There's also a total lack of transparency, not just on the inputs, but also on the outputs. Generative AI tools are increasingly able to produce outputs that can look like photographs, songs, text works that an average person may not be able to distinguish from those made by a human. Moreover, it's been demonstrated by many studies and notably by the 2024 Stanford University AI Index report that generative AI tools often produce exact replicas of copyright content, whether this is through substantial chunks of text from War and Peace, scenes from movies, or copies of whole images, such as the one I'm going to show you on the next slide. Now, whether such output constitutes copyright violations is a central legal question before the courts currently. But the fact that generative AI can produce copyright materials is indisputable. There's also a complete lack of reliability. As noted in WIPO's AI policy toolkit, while today's AI tools may be very good at summarizing text or finding answers to frequently asked questions, they still have very serious shortcomings. According to the WIPO toolkit, for instance, if a generative AI program is asked, for example, to produce a resume of a specific person, it is, and I quote, likely to generate a plausible looking piece of text. In fact, it's likely to read so convincingly well that the reader is lured into thinking it's factual information. But the chances are that many of the entries, such as work placements and experience, are pure fiction. The program will simply have combined words in the most likely statistical order without any real understanding. Alarmingly, a recent survey from the Oxford University Press revealed that while 76% of researchers reported using AI tools in their research, only 27% reported having a good understanding of how to use these tools responsibly. Crucially, AI programs have no notion of truth, no understanding of social norms, and absolutely no regard for ethical behavior. AI programs need substantial post-processing of their output to adhere to such norms. So this next image here illustrates the point I was making regarding the Stanford University Index report. It was featured actually in the South Korean government's generative AI and copyright guide, and it was generated by inputting prompts such as Snoopy and Winnie the Pooh. And as you can see here, the AI tool produced Snoopy and Winnie the Pooh. So creators and rights holders have filed high-profile lawsuits against technology companies who own or control generative AI models, claiming mass copyright infringement. And while these court cases are being heard, governments are increasingly alert to the risks of AI being used, and I quote here from a Reuters article, to disrupt democratic processes, turbocharge fraud, or lead to dramatic job losses, amongst other harms. And governments are looking at regulation at an international, regional, and also national level to ensure that the ethical development of AI that promotes well-being and the safety of citizens. Efforts from international bodies include with the UN establishing an AI advisory body in recognition that the rapid advancement of AI not only brings new opportunities to make gains on sustainable development goals, but also pose significant risks and challenges. WIPO has also published a new IP policy toolkit for regulators and IP officers in order to provide policymakers with a framework to understand the state of play of AI innovation right now, but also to think very critically about the future as AI becomes increasingly autonomous. And the OECD in June published a new report outlining 6 key policy considerations for AI data governance and privacy, emphasizing the importance of transparency, accountability, and security in AI systems. At a regional level, I think we've had a lot of discussion already on the EU AI Act, but I would just highlight here that the big question, the critical question really remains to be answered, and this is whether those rules are going to be implemented in a meaningful and effective way. And I want to emphasize here IFRRO's position that it is absolutely essential that generative AI providers are required to adhere to very clear transparency standards to enable the effective exercise and enforcement of copyright. The EU response has been both lauded and criticised for being too prescriptive, and I just want to highlight here the ASEAN AI guidelines, which provides a very much a light touch approach, which just sets out 7 guiding principles, and the principles are outlined here on the slide. At a national level, activity has been very, very high, but concrete responses are very thin on the ground and vary widely. Many jurisdictions, including the UK, Canada, Australia, New Zealand, and Vietnam, just to name a few, have carried out or have initiated extensive public consultations to assess the path forward. And while some countries are considering the EU approach, others, notably the UK, have taken a much softer approach to regulation and are urging players from across different industries to work together towards a code of practice. I think the previous speaker also highlighted that TEM exceptions are under increasing scrutiny. In the EU, there are fairly clear parameters in place, excluding commercial purposes, and they also include an opt-out mechanism. And in the UK, just last year, legislators opted not to introduce a very broad copyright exception. And I'll quote here from the study that found that the Intellectual Property Office had taken insufficient account of the potential harm to the creative industries, and that whilst developing AI is very important, it should not be pursued at all costs. Other countries, notably Japan, have also taken steps recently to clarify their existing TDM exceptions in response to a proliferation of AI technologies potentially relying on them as a defense for copyright infringement claims. I just wanted to take a moment here to highlight some key governance considerations that I want to call out. Firstly, the Standard University AI Index report highlighted that robust and standardized evaluations for generative AI responsibility are seriously lacking. So the new research from the AI Index reveals that there is a complete lack of standardization in responsible AI reporting. All the leading developers, including OpenAI and Google, primarily test their models against different benchmarks, different responsible AI benchmarks. And this practice really complicates any efforts to systematically compare the risks and limitations of the leading models. Another very uncomfortable truth is that AI technology is currently in very concentrated hands, in the concentrated hands of very few tech companies. And this raises serious concerns about abuse of market power, homogeneity, and also the perpetuation and embedding of biases, unconscious or otherwise. So IFRRO's position is that responsibly and fairly trained AI tools that use authoritative, trusted content and respect copyright laws and copyright owners will undoubtedly produce better outcomes for everyone for several reasons. First and foremost, cultural and creative industries are crucial to society and the economy. The European Parliament, in its 2020 resolution, emphasized the importance of human creators and highlighted that creating an environment conducive to creativity and innovation by encouraging the use of AI technologies by creators must not come at the expense of human creators, and we firmly believe in this. Copies are undoubtedly being made in the LLM and generative AI training process. It is without a doubt that those copies are being made, and the copyright laws that already exist must be applied to the copying of protected works. It's our view that licensing is the most effective approach to bringing AI technologies and copyright together. Lawsuits and litigation will take a lot of time, and maybe they won't all reach the same conclusion, but licensing within a robust IP framework can help now by enabling copyright owners and users to agree on how to responsibly use copyrighted works. Both individual licenses and collective licensing are already widely available in a variety of markets, including text and image-based markets. Collective licenses are particularly beneficial when there is a need to use materials from numerous rights holders, as is obviously the case when using works to train AI. And they can provide sound, efficient, and a fair way to protect authors, artists, publishers, and other rights holders while also benefiting users. Ultimately, IFRRO holds that AI models should only be trained on legally obtained data sources which are transparently reported, and any rights holder opt-in or opt-out mechanism must be fully supported, implemented, and respected across all jurisdictions. As I highlighted earlier, IFRROs exist to offer efficient and comprehensive licensing solutions that facilitate fair and remunerated access to works, and this benefits both users and creators. The landscape of text and image licensing is evolving very quickly, and the need for efficient and transparent collective management mechanisms has never been clearer. IFRROs, with our existing frameworks and our existing international networks, are very well positioned to and indeed must adapt to the AI times. And I want to emphasize here that it is absolutely possible to be pro-copyright and pro-AI. It is absolutely possible and in fact natural to be pro-human innovation and pro-tech innovation. But creators' rights must be respected and AI must be implemented responsibly. When talking about AI, it's very easy to get caught up in the hyperbole and all the tech jargon. So I really wanted to close with this very salient quote from an author who was captured saying, "I want AI to do my laundry and dishes so that I can do art and writing, not for AI to do my art and writing so that I can do my laundry and dishes." Thank you so much for your time today. I'm very happy to take any questions and look forward to discussing with the panel. Thank you.